All right, ladies and gentlemen, we're going to bring in the jury here in just the next few minutes, and then we'll get started. Thank you for your patience. Ms. Steele, I'm just going to give back to you. Will you, Maria, will you give those to me for me? Yeah, I'm going to give those back to you, the ones that you decided not to offer, okay? And you got the time. Awesome. That's awesome. Thank you. That was already packing.
That's the date I put on there.
All right, ladies and gentlemen, let's rise for the jury, please. All right, thank you. You may be seated. Welcome back, ladies and gentlemen. I apologize for the delay, but we were hard at work, and I'm very sorry. All right, just want to kind of give you the lay of the land, what we're going to do today. Momentarily, I will read these jury instructions to you. I will then turn it over to the attorneys for their closing arguments. Each side will be given 75 minutes. It doesn't mean that they have to use all 75. Mr. Schlesinger for the state, he will be permitted to, in essence, provide an argument, and then Ms. Steele, and then he'll be able to respond or reply to that. Mr. Schlesinger has decided to divide his time 38 minutes in the first portion, and then 37 in the second portion, and then Ms. Steele will have her 75 minutes in the entirety. Each side is asked for a warning, so you may hear the clerk or me say a time warning, give them a heads up that they're getting close to running out of time, okay? All right. All right, so ladies and gentlemen, if you would all please listen carefully. You will recall I read to you instructions 1 and 2 in the beginning. That will not be read again, but it will be given to you as part of when you go back to deliberate. All right, the law applicable to this case, strike that, this is instruction number 3. The law applicable to this case is stated in these instructions, and the 2 which the court read to you immediately after you were sworn in as jurors. All of the instructions will be given to you to take to your jury room for use during your deliberations. You must not single out certain instructions and disregard others or question the wisdom of any rule of law. The court does not mean to assume as true any fact referred in these instructions, but leaves it to you to determine what the facts are. Instruction number 4. The charge of any offense is not evidence, and it creates no inference that any offense was committed or that the defendant is guilty of an offense. The defendant is presumed to be innocent unless and until, during your deliberations upon your verdict, you find him guilty. The presumption, strike that, this presumption of innocence places upon the state the burden of proving beyond a reasonable doubt that the defendant is guilty. A reasonable doubt is a doubt based upon reason and common sense after careful and impartial consideration of all the evidence in the case. Proof beyond a reasonable doubt is proof that leaves you firmly convinced of the defendant's guilt. The law does not require proof that overcomes every possible doubt. If, after your consideration of all the evidence, you are firmly convinced that the defendant is guilty of the offense charged, you will find him guilty. If you're not so convinced, you must give him the benefit of the doubt and find him not guilty. Instruction number 5, a person is responsible for his own conduct, and he is also responsible for the conduct of other persons in committing an offense if he acts with the other person with the common purpose of committing that offense, or if, for the purpose of committing that offense, he aids or encourages the other person in committing it. Instruction number 6. As to count 1, if you find and believe from the evidence beyond a reasonable doubt, first, that on or between January 16, 2001 and June 18, 2003, in the county of St. Louis, state of Missouri, the defendant, acting with others, caused the death of Christian Ferguson, and second, that defendant knew or was aware that his conduct was causing or was practically certain to cause the death of Christian Ferguson, and third, that defendant did so after deliberation, which means cool reflection upon the matter for any length of time, no matter how brief, then you will find defendant guilty under count 1 of murder in the first degree. However, unless you find and believe from the evidence beyond a reasonable doubt each and all of these propositions, you must find the defendant not guilty of murder in the first degree. Instruction number 7. As to count 1, if you do not find defendant guilty of murder in the first degree, you must consider whether he is guilty of murder in the second degree under this instruction. As to count 1, if you find and believe from the evidence beyond a reasonable doubt, first, that on or between January 16, 2001 and June 18, 2003, in the county of St. Louis, state of Missouri, the defendant, acting with others, caused the death of Christian Ferguson, and second, that defendant knew or was aware that his conduct was causing or was practically certain to cause the death of Christian Ferguson, then you will find the defendant guilty under count 1 of murder in the second degree. However, unless you find and believe from the evidence beyond a reasonable doubt each and all of these propositions, you must find the defendant not guilty of murder in the second degree. Instruction number 8. As to count 1, if you do not find the defendant guilty of murder in the first or second degree, you must consider whether whether he is guilty of abuse of a child. As to count 1, if you find and believe from the evidence beyond a reasonable doubt, first, that on or between January 16, 2001 and June 18, 2003, in the county of St. Louis, state of Missouri, the defendant, acting with others, failed to provide Christian Ferguson with necessary nutrition and medication, and second, that in so doing, defendant inflicted cruel and inhuman punishment upon Christian Ferguson, and third, that Christian Ferguson was then less than 17 years old, and fourth, that defendant knew his conduct was inflicting cruel and inhuman punishment upon a child less than 17 years old, and fifth, that Christian Ferguson died as a result of injuries sustained from this conduct, then you will find the defendant guilty under count 1 of abuse of a child. However, unless you find and believe from the evidence beyond a reasonable doubt each and all of these propositions, you must find the defendant not guilty of that offense. Instruction number 9. Under the law, a defendant has the right not to testify. No presumption of guilt may be raised, and no inference of any kind may be drawn from the fact that the defendant did not testify. Instruction number 10. When you retire to your jury room, you will first select one of your number to act as your foreperson and to preside over your deliberations. You will then discuss the case with your fellow jurors. Each of you must decide the case for yourself, but you should do so only after you have considered all the evidence, discussed it fully with the other jurors, and listened to the views of your fellow jurors. In deciding what the facts are, you must decide what testimony you believe and what testimony you do not believe. You may believe all, any part, or none of a witness's testimony. You must decide for yourselves whether to believe the testimony of any witness. You must take great care in determining the believability of a witness and the weight to be given to testimony of the witness. You may take into consideration the witness's manner while testifying, the ability and opportunity of the witness to observe and remember any matter about which testimony is given, any interest, bias, prejudice, incentive, or motive the witness may have, the reasonableness of the witness's testimony considered in the light of all the evidence in the case, any benefit that the witness was promised, received, or expected, or any other matter that has a tendency and reason to prove or disprove the truthfulness of testimony of the witness. Your verdict in this case should be based on unbiased reflection after fairly considering the evidence and views of other jurors whose backgrounds and perspectives may be different from yours. Your verdict, whether guilty or not guilty, must be agreed to by each juror. Although the verdict must be unanimous, the verdict should be signed by your foreperson alone. When you have concluded your deliberations, you will complete the applicable form to which you unanimously agree and return it with all unused forms and the written instructions of the court. Instruction number 11. The attorneys will now have the opportunity of arguing the case to you. Their arguments are intended to help you in understanding the evidence and applying the law, but they are not evidence. You will bear in mind that it is your duty to be governed in your deliberations by the evidence as you remember it, the reasonable inferences which you believe should be drawn therefrom, and the law as given in these instructions. It is your duty, and yours alone, to render such verdict under the law and the evidence as in your reason and conscience is true and just. The state's attorney must open the argument. The defendant's attorney may then argue the case. The state's attorney may then reply. No further argument is permitted by either side. All right, well, that'll conclude the instructions, and now we will go to the closing arguments, and Ms. Schlesinger, you may proceed.
Thank you, Your Honor.
Remember to turn the microphone. And there are the instructions. And I have provided for the attorneys a copy of the jury instructions that I just read to you in case they would like to refer to those.
Can everyone see that up there?
Yes.
proceed.
Thank you, Your Honor. Christian Ferguson was 9 years old when he was killed in 2003. And for 19 years, that man right there, Dawan Ferguson, has gotten away with it. It is time that he be held responsible. It is time that Christian Ferguson and his family finally receive justice. So let's start back at the beginning, and let's go through all of the evidence that you have heard in this case. It all began and it all changed on January 16th of 2001. And that is when Christian Ferguson had that traumatic injury occur to him, where he slipped into a coma, suffered severe brain damage, and his life changed forever. He could no longer walk. He could no longer talk. He had to have a feeding tube inserted. Everything changed then. And I submit to you, that is when this all began. That is an action taken by the defendant. You heard from Dr. Grange. She told you that the defendant said that Christian was not feeling well the night before. He didn't call. He didn't take him into the hospital then. He put him in bed, and according to the defendant's own words, checked on him at 11:15 and found him non-responsive. However, you also heard from Sharon Williams, and she told you that the defendant called her that day around 8:30 or 9, and that Christian was having problems then. And he said he was waiting on Dr. Grange because she went to the hospital and she waited for hours. So right there, we already have an inconsistent story by the defendant. And we have a period of several hours where we don't know what he was doing with Christian, but we know he wasn't taking him to the hospital. But even if you believe the defendant's version of that story, it is just as bad. He is trained to look out for the symptoms of a hyperammonemic state. He ignored those symptoms, put his child in bed, and didn't check on him until 11 o'clock the next day. Because of all of that, Christian was in the hospital for the next 6 months, and he would never again be the cute little boy that you saw on that video. That is an action by the defendant. He knew what he was doing then. And Christian's story from that point forward just gets even sadder and sadder. The suffering that this little boy had to endure is tragic, and it is because of him. He was his father. He was the one that was supposed to take care of him, and he didn't. No one wants to believe that a person could be capable of doing something like this, much less a parent. And that explains partially why he got away with it for so long. But you heard from Dr. Grange, if Christian was being seen by nurses for about 40 hours a week, receiving his food and nutrition during that time period, it would be enough for him to limp along. Wouldn't necessarily result in hospitalizations, but it would account for why Christian was not developing or growing. So let's talk about that time period when Christian, thank God, had at least some nurses there. You heard from Trudell Day. She was quite emotional on the stand. She described what she saw in that household in 2002. She would pick up little Christian at the start of her shift. He would be in double-wrapped diapers, urine-soaked all the way through his clothing, where it would drip down and puddle up in his shoes? That's horrible. And you know what? We have the photographs that corroborate what she is saying. Look at Christian's clothing there. You heard from FBI agent Liza Ludovico? That's all biological material, urine, soaked through his clothes all the way down his pant leg, even on his shirt. You heard from Liza Ludovico about the double diapers that she found, saturated with urine, and no fecal matter in there. The only thing she found in there was digested bits of diaper. And she told you that would suggest that he wasn't eating anything because the only thing that was passing through his body was a diaper. Tridell Day told you about how she would watch the medications, and it would be the same from when she would leave on Friday to when she would get back Monday morning. She would find him in the same clothing she left the night before, the same diaper she left before. She had to buy him food. She had to let him use her own son's clothing because it wasn't being provided or it wasn't cleaned by the defendant. All of this goes to show the neglect that Dawan Ferguson had for his own son. March 2003 marks a big point in Christian's life, and in this case. In the first half of the charge period, at least Christian was still being seen by people. But from March of 2003 until June of 2003, no one saw Christian. No doctors saw Christian. No nurses were seeing Christian. His own mother wasn't seeing Christian. And that is the part that is the most alarming here. You heard from Lynn Ferguson. You heard from Deshonda Linwood, who talked about what was going on during that time period. Christian was getting skinnier and skinnier. But when Christian went to that last doctor's appointment on March of 2003, he had dropped 7 pounds from his previous checkup 2 years before. Think about that. A 7 to 8 to 9-year-old child, not growing at all in height, and losing weight. Think about how much a 7, an 8, and 9-year-old grow. That caused them concern. Should the nurses and should the doctors have hotlined this? Yes. Did they? No. But that does not mean that he has not been proven guilty beyond a reasonable doubt. It just makes the story even more tragic. Because everybody, in a way, failed here. But the hospital sent letters trying to get him to come in for checkups. They made phone calls, and they all went unanswered. You heard about Theta's last visit with Christian on March 22nd. She had concerns then about his appearance. She brought him to the hospital. And she said goodbye. And that was the last time she ever saw her son. At that point, the nurses were gone. There was no one in the home to care for Christian other than himself. The defendant didn't bother to do a thing. That's when the medications stopped being picked up. That's when the food and nourishment stopped being ordered. There was no one to do it now. It was all his responsibility. And he didn't do it. You heard. They would shut him in his room, tie him to a bed, and forget about him. He and Monica lived in the basement. You saw the basement. That's where everything was. You saw the upstairs. The living room had nothing in it. There was a formal dining room table that the kids weren't allowed to use. Christian was confined to his bedroom, tied to a bed by his father. There was evidence that they would tie him up, turn out all the lights, and leave him there while they would go to dinner. Who does something like that? What this child had to endure is horrible. He already had so many struggles in his life given his condition. And he was an inconvenience. And every act that the defendant did during that time period is a deliberate act. It goes to the deliberation for the murder charge. Every time he didn't give him his medicine, every time he didn't feed him, that was an act that was killing him. And finally, in June 9th of 2001, time's up. He couldn't get away with keeping Christian from anyone any longer. Theda filed a motion in court, and it was set to go before a judge. You heard from Sharon Williams, who talks about the end of May around Memorial Day. The defendant came to her upset. Tell Theda to drop this. Why do we have to go back to court? Can't she just wait until the kids are older? And then he said, Theda will get those kids over my dead body. He did not want to have to show Christian to anyone because he knew he was going to get caught. Based on his actions, it could be inferred he was hoping Christian would die naturally, and it just hadn't happened yet. So we go to that June 9th court hearing, and you heard from Mary Ellen Pennick, who observed the defendant when that order was read. He was upset. He was angry. He looked frustrated. Because now he had to figure out what to do. And that takes us to the night of June 10th, the early morning hours of June 11th. You heard from Lynn Ferguson. She remembers seeing Christian's G button not in his stomach that day. She told Monica, said she was aware, didn't care. You heard from Monica. Doesn't sound like she cares about anything. And then that night, Christian's moaning, groaning. If you remember from that video from the Child Advocacy Center, Connor demonstrated what Christian's eyes looked like. They were rolling in the back of his head, eyes fluttering. According to Dr. Grange, that would mean that Christian was entering into one of those hyperammonemic states, or was in one already, and would not be able to survive for 24 hours. But Dawan went into that bedroom, and he took Christian, moaning, groaning, took him in the other room. Now, we don't know what happened in there. We don't. But we know that the moaning stopped. He was taken back into bed, later wrapped up in a blanket, and walked out. That's what Lynn knows. That's what Lynn remembers. She told you on the stand that I don't think she processed that fully when she was an 8-year-old child, but looking back on it now, she believes he was gone at that point. And then you heard from Deshonda Linwood. When she was coming back from the bathroom, she saw the defendant carrying Christian, wrapped entirely in a blanket. She described it as somebody wearing a hoodie backwards, the face entirely covered up. No one wraps a sick child entirely in a blanket like that, covering their face, mouth, nose, especially not in the middle of June here in St. Louis. No. He wrapped Christian in that manner because Christian was dead at that point. And he left the house, and he was never seen again. So let's talk about that 911 call. The defendant's version of what happened is bogus. And that has been proven to you. Absolutely. The 1999 Ford Expedition, according to Dawan, was last seen driving eastbound into the city of St. Louis around 6:07 a.m. Well, you heard that the sun rose that day at 5:36. And you heard from Andrea Murphy Johnson and Mark Ellis, two people who don't even know each other. One of them doesn't even live in the state anymore, and neither of them know the defendant. And both of them saw that car on their street around twilight. She said around 5:15, and that would make sense. If sunrise at around 5:36, I believe twilight would be around 5:04, 5:15, leading into that time period. They all were very descriptive. It wasn't entirely dark, but it wasn't entirely light out yet. It was that in-between time period. The defense tried to poke holes in a lot of things. They were not able to poke a hole in that story at all. You can't change or poke a hole in the time the sun rises, and you can't poke a hole in two independent witnesses who have nothing to do with this case saying they saw that car there at 5:15. Almost an hour before the defendant made that 911 call. Now, yes, you heard yesterday from Dion Dupree. I don't think we need to say another word about Dion Dupree. His testimony was a joke. Look at the instructions. Look at what you can consider when assessing a witness's credibility. Look at Dion Dupree versus Mark Ellis and Andrea Murphy Johnson, and you tell me which story is more believable. But that's not it. We also have the whole issue with Lakeisha Mays and her car. If you look at that map, and I know it's hard to see on here, so let's go. Here is that little street Rombar. And here is that street Disco Drive. You heard from Andrea Murphy Johnson. She saw another car speeding away at the top of the street. She can't tell you what it was, what kind of car it was, but she knew that the expedition was on the street. Well, Lakeisha Mays lived half a mile from Rombar on Disco, and her car was already seen at the intersection of Page and Hodemont, right by that payphone, by Fox 2 News footage at 7:48. According to Lakeisha Mays, the defendant himself borrowed her car and got a ride somehow, some way. We don't know how. We don't know why. But we know it's false because the defendant was with the police from 6:07 for the next several hours. So he could not have gone up to Disco Drive and gotten that Malibu and then driven it to that intersection. It's not possible. You heard evidence that there were bags of Lakeisha's clothing found in the Malibu. Those bags of clothing were left at Dawan Ferguson's house. They were not in her car the night before, but they were in her car the next day. He put them there. He left them there, probably hoping no one ever would make the connection to a random car being parked on a street. Thank God the police did. And also found in her car that she had never seen before was a large black flashlight, like a police officer's, also like a bounty hunter's. The defendant's 911 call is ridiculous, and therefore Christian Ferguson was never missing. The defendant, acting with others, concealed the body. Now, Christian Ferguson has never been found. But we talked about this in jury selection. And there is no requirement, no element where a body is needed. So let's talk a little bit about what I do have to prove. These are all the jury instructions that the court just read to you. You will get a copy of these when you go back to deliberate. So you don't have to worry about writing it down. You can see it back there. This deals with the issue of acting with other people, okay? Because there were several people potentially involved here. What your goal is to decide the defendant's responsibility. Here it says, a person is responsible for his own conduct, and he is also responsible for the conduct of other persons in committing an offense if he acts with the other person with the common purpose of committing that offense, or if, for the purpose of committing that offense, he aids or encourages the other person in committing it. That instruction applies to all of the then 3 verdict directors you will get, okay? So when you see acting with others, that's what it refers to, and it means the defendant is still responsible.
Does anyone object to the statement of the law?
I like this approach. All right, so you may resume when you're ready. We'll start your time then, okay?
Thank you. Like I said, that instruction applies to all of the verdict directors, okay? Here's the verdict director. And do you remember when we talked about, in jury selection, the elements and the things that I had to prove? We talked about it for probably too long, but it's important. So here's why. For count 1, and this is murder in the first degree. The first element is that honor between January 16th, 2001 and June 18th of 2003. It's a wide range, but it encompasses everything that we have talked about, and that is why we are discussing that time period. And there's been no dispute at all with regard to the time period. In the county of St. Louis, state of Missouri, the defendant lived at Sylvan Place in Pine Lawn in St. Louis County. Again, no one is disputing that at all. The defendant, acting with others, caused the death of Christian Ferguson. The defendant had sole legal and physical custody of Christian Ferguson. He was the one responsible for taking care of him. He is the one that was responsible for getting his medication, his food, cleaning him, taking care of him, and he never did it. Well, he didn't do it nearly as much as he should have. You heard from the pharmacist. I don't know if you remember that striking number that she gave. The prescriptions that were ordered during that 2.5-year period would have been enough for about 300 and some odd days. But it was for 580-day time period. Think about that. The life-sustaining medications for Christian Ferguson, his father only got him enough medication for about 300 plus days. And he expected that to last for 580. He caused Christian to lose weight, caused his ammonia levels to constantly be elevated, didn't care for him, brought him to the brink of death, and then that night he took him out and he killed him. It was the defendant that caused Christian's death. Second, that the defendant knew or was aware that his conduct was causing or was practically certain to cause the death of Christian Ferguson. Of course he knew. Of course he was aware that not giving his child the life-sustaining medication, not feeding him, it was practically certain to cause his death. He knew the risks. You heard from all the medical providers that talked about how he was educated on what to look out for, on what to give him, and why it was important. He didn't do it, and he knew of the risk. The risk was Christian would die, and Christian did. And third, that the defendant did so after deliberation, which means cool reflection upon the matter for any length of time, no matter how brief. So let's talk about deliberation. Oftentimes, people think deliberation means you have to have this incredibly well thought out plan where you organize something, you do it, it's done. No. Deliberation comes from the word deliberate, a deliberate act. It is a cool reflection upon the matter, no matter how brief. No matter how brief. But actually, in this case, we have years of deliberation. Every time he didn't give him his medication, every time he didn't bother to feed him, he knew what he was doing, and he didn't do it. That is a deliberate choice he made because Christian was an inconvenience he didn't want to be bothered with. Every time he saw the warning signs of a hyperammonemic state and delayed bringing him in, that was a deliberate choice by the defendant. And then that night, going into his room, that was a deliberate choice. Picking him up from his bed and taking him into the other room, that was a deliberate choice. And whatever struggle occurred in there, whatever he did to little Christian, that was absolutely a deliberate choice. And then he took him from the residence, did something with the body, and then planned a cover-up. We have met the element of deliberation. And that's it. The next line is quite clear. Then you will find the defendant guilty under count 1 of murder in the first degree. 3 elements. That's all I have to prove. And it has been proven to you. It's not, Your Honor.
Hold on a second. The objection's overruled. You may continue.
There are 3 elements to murder first, and all 3 have been proven to you. Then you will find him guilty of murder first. But let's talk about the other ones. Murder in the second degree, I don't think we need to focus on it too much, because it's the exact same as murder in the first, minus the third element of deliberation. Nothing else changed. Same dates, same time period. The defendant acting with others caused Christian Ferguson's death, and that he knew or was aware that it was practically certain to happen. That's it. Then you will find him guilty of murder second. But you only get to murder in the second degree if you do not find him guilty of murder in the first degree. Everyone understand that? So you start out with murder in the first degree. You read through the elements, and if for some reason you do not find him guilty of that, then you must look at murder second. Okay? And then we have instruction number 8. Now this one reads, if you do not find him guilty of murder first or murder in the second degree, you must consider whether he is guilty of abuse of a child. Now there's more elements on here, so let's talk through them. The first one, same date, time range, location. Again, none of that's disputed at all. That the defendant, acting with others, failed to provide Christian Ferguson with necessary nutrition and medication. You've heard from the doctors. You've seen the medical records. You've seen the pharmacist. He absolutely was failing to provide Christian Ferguson with his necessary life-sustaining medication. You saw that chart. 30-day supplies. That's all it was supposed to last for. And Melissa Heim described they were extended through 42 days, 70 days, 80-some-odd days, 120 days. One of them, I believe, was 141 days. That proves that Christian Ferguson was not receiving the necessary medication that he needed to survive. These were not drugs you could just pick up at a local pharmacy. That's not how this went. And it got so bad, where he hadn't been seen from a doctor in almost a year, that they wouldn't even refill the prescription without seeing Christian. And even then, the defendant didn't even bother to go. The nurse brought him. It is crystal clear that Dawan Ferguson was failing to provide Christian Ferguson with necessary medication. The first element has been made. And second, that in doing so, the defendant inflicted cruel and inhuman punishment upon Christian Ferguson. This child's life was punishment. What he had to endure and suffer was cruel and it was inhumane. The food and nutrition alone was starving him. He was losing weight. He wasn't growing. He was eating his own diapers. Now, I imagine the defense might point to the disease pica, but you heard actually from the experts who say that he would put things in his mouth, but he wouldn't actually eat them. But he was eating his diapers, because that's evidenced by what was found in his diapers. Only diapers, digested diapers, no food, no other fecal matter. That is cruel and inhuman punishment, coupled with the fact that he was left in his own soiled diapers, left in his own soiled bed, strapped to that bed, left in a room for hours, no supervision, no one checking on him. All of that is cruel and inhuman punishment. And third, that Christian Ferguson was then less than 17 years old. Again, that is not disputed at all. He was 9 years old at the time. Fourth, that the defendant knew his conduct was inflicting cruel and inhuman punishment upon a child less than 17. Of course he knew. He knew and he didn't care. He locked him away in that room and pretended like he didn't even have him. Wanted to go out to dinners, wanted to have his life, wanted to work. Got away with it when he had the nurses there at least. But from March forward, it was all on him, and he couldn't be bothered to care for that special needs kid. And that is terrible. And fifth, that Christian Ferguson died as a result of injuries sustained from this conduct. Like I said earlier, Christian Ferguson was put to the brink of death because of the defendants failing to provide him with all of this proper medication and nutrition. That's what got him to the brink of death when the defendant killed him. He is absolutely guilty of child abuse. Again, the next line reads, then you will find him guilty of it. Now again, like we discussed in jury selection, you must find and believe each and every element. If you don't, then you must find him not guilty. But that's not the case here. The defendant is guilty of murder in the first degree. He's guilty of child abuse resulting in death. But let's make this very clear. You can only find him guilty of one. So you start with murder first. If you don't find him murder first, then you move to murder second. And if you don't find him guilty of either murder first or murder second, then you move to child abuse. But make no mistake. Dawan Ferguson killed Christian after deliberation, and he is guilty of murder in the first degree. I said earlier that no one would ever want to believe that a person could be capable of this, much less a father. And we also talked about how the system failed Christian. He was a little boy. His life mattered. The people that surrounded him sucked. And his death has gone without any justice for 19 years. You heard from the witnesses. Dawan Ferguson was arrogant. I have a rich stepfather who can get me out of anything. And it worked. You heard about his criminal defense lawyer who went into the house on Sylvan 9 days after Christian was reported missing by the defendant. And you know the only thing they took? The medications. What does that tell you? They brought in Christian's sister the day before he was supposed to be returned to his mother, in the presence of the defendant's mother, in the presence of his defense lawyer, and they questioned him.
2 minutes.
Thank you. Dawan Ferguson has gotten away with this for too long. So many people failed Christian. Don't you fail him too. The defense attorney is going to get up here, and she's going to make her closing argument now. There have been a lot of distractions throughout this whole case. Like I said earlier, the statements of lawyers, the arguments of lawyers, the questions and objections by lawyers are not evidence. Focus on the evidence. The overwhelming evidence of neglect. The evidence that proves he killed him. The things that have not been disputed. Focus on all of that. But when she's done, I will have an opportunity to talk to you again. And at that point, I will ask you to find the defendant guilty of murder. Thank you.
All right, thank you, Ms. Steele. Closing argument.
Thank you, Judge.
You may proceed when you're ready.
Thank you, Judge. Good afternoon, everyone. I want to thank you for your patience, attention, and time this week during the trial. Honestly, excuse me, While listening to the state's evidence this week,
Ms. Steelman interrupting. Do
Yeah.
you want this down?
oh, yes.
Yeah, he'll get, I'm sorry, I just noticed that, so stop
No,
your
that's
time.
fine.
I apologize. Thank you. I apologize for the interruption. You may resume.
Okay, thank you. While listening to the state's evidence this week during the trial, it almost sounded like we were here to decide whether or not Dawan Ferguson was a good parent or not. And that's not a murder trial. What we've heard is a lot of innuendos, a lot of rumors, a lot of suggestions, and a lot of theories as to what they think happened. But we haven't heard any evidence as far as what was the cause, or if Mr. Ferguson was the cause of Christian's death. We haven't heard anything like that. And that's because, honestly, the state doesn't know. I mean, you've heard we have these alternate charges here. They don't know. They don't know if it's just deliberation. They don't know if it's medicine. They don't know if it's nutrition. They have no idea. They do not know. It's almost like that saying where you throw something against the wall and see what sticks. That's what this trial has been. But let's refocus here, as Mr. Schlesinger says, because there is a lot of innuendo, and yes, Christian, it does sound like he had a hard life. And I have the most empathy for Christian. I do. Because no child deserves to have a rare genetic disease, and it makes daily life difficult. So I empathize with that. But again, this trial is not about whether Dawan was a perfect dad or whether his parental rights should be terminated, but that's what it's felt like sitting here this week. They've been putting on evidence that he's a bad dad, not that he's a murderer. Don't let the state confuse you about that. This is a criminal trial for murder. And the question for this jury is to decide if Dawan Ferguson caused the death of Christian Ferguson, and they have to prove it beyond a reasonable doubt. And they obviously have not done that. And I do want to apologize for all the objections I've done this week and just now during closing. I know it's not pleasant, but it's absolutely necessary for me, because I'm standing up here and I'm fighting for Dawan. And I'm standing up here and I'm fighting against innuendos and rumors and suggestions that can convict someone of murder. So again, reasonable doubt just in general. The state has to prove every element beyond a reasonable doubt. No one has a burden of proof as to a kidnapping. That's not one of the charges here. But they have to prove every single element beyond a reasonable doubt in order to find Dawan guilty of something. And if even on one element, if you do not find beyond a reasonable doubt, that's not guilty. And we talked about that during voir dire. So again, to the murder one that they talked about, you have to find beyond a reasonable doubt that there was deliberation. And the other element is you have to find beyond a reasonable doubt that Dawan caused Christian's death, which we do not have here at all. You don't have deliberation, you don't have Dawan caused his death, and you do not have beyond a reasonable doubt that he knowingly caused his death. The state has not presented any evidence at all. Through all of their 29 witnesses that they had here this week, 0 witnesses provide anything for any of these elements. It is not guilty as to murder first. Same for murder in the second degree. They have to prove beyond a reasonable doubt that he caused his death. We have not heard any evidence that Dawan caused his death at all. We have not. And the other element of murder second is that the state must prove beyond a reasonable doubt that he did conduct practically certain to cause the death. Again, we do not have that here at all. And then in the alternate count, because again, the state has no idea. They have no idea. The abuse or neglect resulting in death. The state, again, has to prove beyond a reasonable doubt that Dawan caused Christian's death. We do not have it. You do not have that element. It is not guilty. The most obvious way to look at the cause of death situation and see how the state has not proven it is that they haven't even proven death. Most murder trials have a body, an autopsy, medical examiner who can tell the jury what the cause of death is. I know this is a unique situation. I know we do not have that here. But again, as I said, 29 state witnesses and 0 told you what the cause of Christian's death was. The actual cause. They can't tell you a suggestion, what they think. No, it has to be the actual cause of the death. It got confusing because there's all these possibilities. Oh, it's medication, it's nutrition, it's this. No, it's not what we think it is. It is what is the cause of the death.
Your Honor, I'm sorry, but I
Why don't you come up to the
Thank
side,
you.
please? All right, ladies and gentlemen, there was an objection raised as to the last statement or statements made by Ms. Steele. The court has sustained that objection. We'll instruct you to please disregard the last statement, and it will be stricken from the record as well. So, Ms. Steele, if you want to resume and maybe say that in a different way.
Sure.
Thank you.
Oh, go ahead.
Oh, you may proceed, yes.
Okay.
Sorry.
No, it's okay. We have all kinds of reasonable doubt here, and that means not guilty. If it's possible Christian's alive, it's not guilty. If it's possible that Christian was kidnapped, it's not guilty. If it's possible that Christian died of his disease, it's not guilty. Remember, no one has to prove to you beyond a reasonable doubt that anything's happened to find not guilty. State has to prove beyond a reasonable doubt that Dawan caused the death of Christian. Anything less than that is not guilty. So let's talk about this confession that didn't happen. And that's the only direct evidence of murder in this case, is Santana's alleged witness confession. But this is obviously a confession that just never happened. You saw what happened when she was on the stand and she was testifying. She couldn't keep her stories together. She said she told Sonia about this confession from Monica and Dawan. Well, Sonia came in here, sat down, and told you, absolutely not. Never told me that. And a matter of fact, her words were, I would have told somebody if that happened. It didn't happen. And she said that it happened in front of Monica. Monica and Dawan made this confession to her. Well, Monica came in here, she sat down, and she said, absolutely not. That did not happen. And another big reason how you know that that didn't happen is because she didn't say anything to the police for 15 years. She claimed she was scared and that she didn't know what to do. Even though she says that Dawan never threatened her. And I asked her, I said, well, if Dawan had threatened you, what would you do? Well, I would have called the police. So she does know what to do if that actually happened. But that confession never happened. And she also, don't forget, had Sergeant Bartlett, a police officer, in her family, even back then in 2004 when this alleged confession happened. You don't know what to do, but you have a police officer in your family, and someone confessed to killing a child? It didn't happen. The way you can tell if a confession is real or not is if it gives some sort of, I don't know, details that's not known to the public. And what she said was nothing unique. This was all over the news. Sick kid, medicine, you know. It was general information. It was nothing specific. And don't forget that she talked to Theda before she talked to Ron Goldstein, who took her statement. And I think another thing Santana said was, well, it was so long ago I forgot some things from this confession. It didn't happen. And the other thing is, that was odd, is that she claimed she got this letter. That she wrote this letter to her mom just in case something happened to her after she gets this confession. And her mom she puts it in an envelope, gives it to her mom puts it away. And so when she's talking to Ron Goldstein about this confession, he's like, do you have anything that memorializes this? And then she later comes back, I have a letter. And her testimony was, she came to St. Louis from Arizona. She came to St. Louis, got the letter from her mom in the envelope, went back to Arizona, and then sent it here by email. Well, if she's here, wouldn't she just give that to law enforcement herself? The story is nonsense. And the circumstances of this confession, that's also really bizarre. So, if you're listening to what she's saying, Dawan is confessing to a woman that he's met 3 times, not friends with his wife. Her and the wife just worked together. She said she's an acquaintance, didn't have phone numbers, didn't go to the house, didn't know her children. And this confession is when trying to lure someone into a relationship? So they confess to murder while enticing her to be with them? This didn't happen. Santana had a motive. Her and Monica had issues. You heard about the sexual harassment claim. And let's not forget, though, as well, he allegedly tells this to this woman that he barely knows, but you heard Ruth Coleman on the stand, someone who actually lived with him was a live-in nanny / girlfriend that he still would talk to from time to time after that, who wore a wire. He didn't confess to her. He knows her more. They live together. Dawan didn't confess to anyone because he didn't kill anyone. Santana's not credible. She claims that she was scared of Dawan, but he never threatened her. She moved. They didn't have her address, didn't have her phone number. Changed her name 14 years later. Claimed that she said it's for domestic, but it was for this. And we don't have a police report on this. She talked to the investigator that works for the prosecutor's office. And that's who she talked to first. And like I said, before she talked to him, she talked to Theta. And that's where she got the information from. Again, this is all general knowledge. Stepdad, white guy, works in construction. I mean, again, nothing specific, all very general. This was in the news. Theta had been in the news talking about this. Nothing specific. And the other easy way to disprove this is that Santana, I got her to say on the stand, what she told Ron Goldstein was, they said he was dead 2 days before, not more than a week. Well, Monica said he was alive June 10th. Lynn said he was alive June 10th. DeShonda said he was alive June 10th. It's not true. Christian was alive on June 10th. The confession never happened. And part of this confession involves something with construction or foundation or house, whatever. Well, you heard Harry Howell on the stand, and he said that Theta and her then husband at the time, Victor, had mentioned to him about Christian being in a construction site or something like that. Remember, he said that. And they looked into it. They looked into some of the properties. They did. And they didn't find evidence of anything of Christian potentially being buried there. Didn't find it. So they moved on. As I stated, a lot of this evidence, but a lot of innuendos here are like suspicious statements made by Dawan. For example, Barbara Flory, who testified, who worked at the Heritage House that watched the exchanges. She's talking to Dawan. He was late for the exchange. And he opens up to her about the difficulties of being a caregiver of a disabled child. And she said she put on her licensed social work hat when talking to him. She said that. It's not suspicious. So is it suspicious to vent frustrations about being a parent? I mean, I know being a parent of a regular healthy child is hard as it is, but imagine a child who has this rare genetic disorder that Dr. Grange said 1 in 50,000 have, and he has a severe type, who has a regimen of medication and food. That's tough. It's okay to vent. Venting doesn't mean you murder. And I asked her after that conversation, did she, because she's a mandated reporter, did you call DFS? Did you call the police? No. She wasn't concerned. She didn't think that any of the kids were in harm's way. And then we heard about Sharon Williams, Theta's sister, who already would have a bias against Dawan. So she's going to be on Theta's side. And that dead body comment, I asked Special Agent Wisely DeVico about it. And Liza said, when I had her testifying, when she did her reports, the 302 report, she took copious notes, put it in the report. And I asked her, refresh your recollection, look at that report. Anything about over a dead body? No. Complete exaggeration. He didn't say that. So let's talk about the medical evidence in general. Dr. Grange is the expert. The LPNs are not the experts. Nurses, none of family, they're not the experts. Dr. Grange is. And she said herself that that disease could sometimes make it hard to gain weight. You have symptoms of vomiting, loss of appetite. And just because a child with citrullinemia loses weight, as she said, doesn't mean the caregiver did anything wrong. There can be other reasons for that. And by all means, it does sound like managing citrullinemia can be difficult, because she stated that Christian did some hospital time at Rankin Jordan after the coma, which is a step down. I think it's a pediatric bridge hospital where he stayed for a while. And even there, where he's getting the best top-notch care, he had some hospitalizations. That's hard. And she also said, with citrullinemia, there is a lower life expectancy. She said that. And let's talk about the weight loss. So at the March 2003 clinic appointment with Nancy Brody, and that's where the home health nurse, Kim Nelson, brought Christian. I believe labs and blood work was done. And while there, an error was discovered. And the error was discovered in the plan of care that Maxim Healthcare used for the nurses to have to know how to treat the patient. And they realized there was an error in that, and it was adjusted while she was there at the meeting or the appointment. The medication doses weren't changed. They just upped the protein to help with the weight loss. Lastly, at that appointment, Christian was not admitted into the hospital either. By all means, it sounded like he was doing okay. And Dr. Grange, I believe, blew a hole in one of the state's theories when she testified. She testified that in her training and experience with citrullinemia patients, if a child with the disease goes a few days without the correct amount of life-sustaining medication or too little of it, that's exactly how I worded it, the child will have a hyperammonemic episode. And remember, I kept building on that question. So that means they can't go weeks without the proper dosage, months without the proper dosage. But that's their theory, that he wasn't given the proper dosages over time. But Dr. Grange is like, that can't happen. If you don't give the proper dosage over time, and again, a few days, you're going to have an episode. And their time period is over a year and a half, 2 years. And even if they're talking about the March to June, impossible. And let's not forget that Dr. Grange wasn't an expert that I retained. She testified for the state. And she actually knew Christian his entire life and his family. So she would know. And the state had talked about a lot, again, not evidence of Dawan causing a murder, but they talked a lot about the urine smell in Christian's bedroom. First of all, Christian was incontinent, and he wore diapers. We know that. And Dr. Grange explained the process of the medications to manage citrullinemia, where it pulls the ammonia out through the urine. And I asked her, I said, well, and it's ammonia scavenger medication. And she said it's not uncommon for these patients to have an odor because of the medication. And again, if it's ammonia coming out of your body, that's pulling the ammonia out, ammonia has a strong smell. Reason and common sense. And the state mentioned about the diapers that were found when the FBI did the search of the house with Special Agent Liza Ludovico. But they also found 4 empty cans of Pediasure. And yes, Kim Nero and Trudell Day both testified that Christian had pica, where he would put almost anything in his mouth. They have to watch him. And I believe then Connor also said that in the CAC interview, that that's what Christian would do. And Liza said that some diapers had some fecal matter, not all of them, and then some of them had the material in it. Well, that's why. Pica, but there was fecal matter. I think it would be more alarming if you found diapers with no fecal matter or whatever, but there was fecal matter found. There were 4 empty cans of Pediasure found. It's nothing. And the G button is a red herring. You find an old G button at the house after Dawan had moved out of it. It means nothing. We heard testimony that Christian's G button had come out before. And you also heard testimony from Dr. Grange that it's not uncommon for a G button to come out. Kids could pull it out, it could come out. And also, she said, you can replace the G button if it's cracked. And a parent that's trained to do it or experienced caregiver can take it out and throw it in the trash and then put in a new one. And you don't have to remove the G button in order to give food, because he could eat orally, but a low protein amount. So it doesn't make sense. I know that it sounds bad when they say it at first, but when you zoom into the logic of it, it makes no sense. And that's a good metaphor for this trial. And yes, Trudell Day, one of the home health care nurses. You saw her on the stand. It was obvious she's not a fan of Mr. Ferguson. Well, Kim Nero was the nurse that came after Trudell Day. And she said when she got there that the Maxim book that they put in the nursing orders was a mess when she got there. But Trudell Day tried to allude that Christian's G button was out over an entire weekend, and she had to take him to the hospital and get it put back in. But Dr. Grange testified that the stoma can close within a couple of hours. Trudell Day just had an axe to grind, because honestly, Rogers do that? Well, again, as I stated, when Christian went missing, this was all over the news. And who else was in the news making accusations against Mr. Ferguson? Theta. So, because of that, what's the best way to defend himself against those accusations? Third party, you get that stuff, give it to the police when they ask for it. Kim Nero said she never ran out of medications in that house. When she went to that appointment with Nancy Brody and she was shown some record dealing with meds, she said she was perplexed because she never ran out of medication. And when the FBI searched that house, all of the medications that Christian needed were in that house. All of the life-sustaining medications, Pediasure, G-buttons, medical supplies, it was all in the house. And John Rogers further helped Dawan defend himself against the accusations in the press and media, again, the rumors, innuendos, by having a conversation with Lynn, then Connor. And he testified that he's talked to dozens of children. If he decides he doesn't want to speak to them, he doesn't. And they had a conversation. We read it out loud. And at no time did he say anything about a murder happening. He told John Rogers the truth. Then Connor did. No murder happened. And pharmacist Melissa Heigeman, she wasn't Christian's doctor, and she's not a doctor. She's a pharmacist. So she's not in charge of what medications Christians are supposed to get, when, how often. And then she makes this chart for the prosecutor for medical records based from 2003. But again, Kim Nelson said she never ran out of medication. And she was the nurse, I believe, from September up to March 6th of 2003. And she never ran out of medication. These records are inaccurate. Even she said that. I don't understand it. He always has medication. I don't have an issue with that.
Your Honor, I'm just going to object as to stating facts never in evidence.
That wasn't
It'll be overruled. The jury will be guided by the evidence as they remember it. You may continue.
The other issue that the state has with this case is that Dawan has no motive to kill his son. None. There's no life insurance policy, no financial windfall. The state's grasping at straws for a motive because they have no idea. They don't know. And what they're trying to say isn't supported by any evidence, and it just doesn't make sense. Because they're trying to say he did this to get back at Theta for a court hearing in June. So let's talk about that court hearing. Nothing changed at the court hearing. There was no change in custody. There was no change in... there was no change. There was nothing happen that would cause that. It was visitation needs to resume. So again, that motive doesn't make any sense. Let me talk a little bit about Lynn. The reason why I spend so much time bringing up what Lynn said before is because Lynn's statements now are a complete 180 from what she said back in 2003 on. And she's had multiple opportunities to speak. She's talked, you heard a conversation recorded with her mom. There was others. She talked to the CAC. She talked to the police. She talked to John Rogers. And in none of those statements, any of those statements, did she ever say that she heard this incident in another room. She's never said that. In all of those statements, she said Christian was being fed, he was getting his medication, and he was alive and breathing when Dawan had taken him to the car. Nothing about Dawan taking him into another room and hurting him. It's completely made up. The idea that Lynn was under the influence of Dawan's parents is preposterous. Because in those conversations in 2003 with her mom, it was just her and her mom talking. And then I think at one time her mom's husband was in there talking. And you heard it. They're laughing. They're having a good time. And they're still talking about the night before Christian went missing and the morning of. Dawan's not there. Dawan's parents aren't there. Same at the CAC. Dawan's not there. Dawan's parents aren't there. Talk to the police. Dawan's not there. Dawan's parents aren't there. There's no influence. Lynn had been consistent until 2018. And that's because nothing happened. So why is she changing her story now? And that's what makes that confusing. I am sensitive to the fact that Lynn's had a tough life. I'm sensitive to that. You're between parents that hate each other. Your brother disappears. You move in with your grandparents. That's hard. But we also saw or heard in that interview that I played between Theta and then Connor, of Theta starting to plant the seeds a little bit. She's talking about Christian's bones. And then Connor said,
Your Honor, may we approach?
You may.
Thank you.
All right, ladies and gentlemen, there was an objection raised. The court has sustained the objection. Counsel's last statements about this audio recording, or those statements, plural, should be disregarded, and they'll be stricken from the record, so you may continue with your argument.
Thank you, Judge. And then Connor's conversation with John Rogers that you heard yesterday. She freely admitted that Theda would say terrible things about her father. And that's wrong. That's unfair. And it's manipulation. And what do we see now? A young woman who's fed into her mom's anger. So what does she do? In 2018, she goes and does a whole nother statement that's against her father. That everything can get so twisted after 20 years. Thank goodness we can show the statements that she made prior that had been consistent until 2018. When you're deliberating in the jury room and you're debating each other on just how bad things were in this house or with Christian's medical care, just remember, Dr. Grange never reported him to DFS or the police. Barbara Flory never reported him to DFS or the police. Trudell Day never reported him to DFS or the police. Kim Nero never reported him to the police or DFS. Mary Ellen Pinnock never reported him to DFS or the police. And Nancy Brody did not either. And that's because nothing happened that rose to the level of their concern. And these are mandated reporters. They're legally obligated to do it. And they didn't. The state wants you to believe that Dawan was like slowly killing his child in front of home health care workers, doctors, whatever. And none of them noticed. Because if it was remotely true, one of them would have called DFS or told the authorities about it. But that's not what happened. And I want to talk to you about the kidnapping. Remember, there's no burden of proof here to say that the kidnapping happened. They'd have to prove to you that the kidnapping happened in order to find Dawan not guilty. Because this is not a trial about the kidnapper or the car. But the kidnapping story is important because the state has still not disproven it, which means that there's reasonable doubt that Dawan caused Christian's death. They say that there's no way that a car thief would have stolen a car with a kid in it, and the kidnapper would have dumped the car quickly if they realized there was a kid. But you saw Detective Wolf, who was here, and he testified. And in his training and experience as a police officer, he's had many cases where car thieves take a car with a kid in it, and they dump the car. But if you have a sick child in the car that is nonverbal, it might take longer to notice there's a kid in the car. I don't know. And they say that there's no way that a car thief would have dumped the car and left that stuff in there. Well, let's talk about what's in the car. I think they said a bulletproof vest and some handcuffs. And I think it was Officer Creeley that testified. It looked like maybe the inside of a cop car. Well, yeah. You get in the car, you see all that stuff. Probably did dump it. I'm getting out of here. I'm not touching this. Looks like a cop car. And the best evidence that there was reasonable doubt is that, no, Mr. Schlesinger discredited Beyond Dupree. Yeah, he's a little kooky. But he said on that stand, that's the car that I saw. I was at the day camp. It's over there in Hodemont. And I saw this purple car speed off. And he also corrected himself and said, well, I use car and SUV interchangeably. But that's the car I saw. And Ms. Tremaine said, well, how do you know it's that car? Well, I saw it on the news. That's the car. Didn't tell anyone at the time because no one asked him about it. Which goes to show you how the cops kind of treated this case. And the best part about some of this is that some of these witnesses that I've mentioned in my closing, like Dr. Grange, Detective Wolf, Deion Dupree, Sonia, they have no reason to help Dawan. They have no dog in this fight. As far as Lakeisha and the gold car, the only solid proof of when that gold car was near the payphone was the news footage on the screenshot that was shown, and it said 7:48 a.m. It's like an hour or so after Dawan called the police. The most reasonable explanation for this car is that Dawan, who had keys to the car, had someone bring it to him. Lakeisha said Dawan had keys, her friend Tanae had keys, her mom had keys, I think she said Monica had keys. So yeah, he was calling people. This is what happened. Hey.
Your Honor, arguing facts never admitted into evidence.
That'll be overruled. The jury will be guided by the facts as they remember them, and I would caution both counsel, though, stick within the facts that were presented to the jury, okay? You may continue.
Thank you. So the car was abandoned on Ron Bar, and the neighbors' accounts for the times, they're kind of all over the place, actually. When then Connor was talking to John Rogers about the night and morning into Christian's disappearance, he asked about what time did his dad leave the house. And he said the sky was kind of dark, but starting to get light out. And I believe the state said the sunrise was 5:36. And if it was 5-something, I think one of the testimony was 5:15, it was still dark out. This whole trial has shown you that you can't rely on human memory for times. Plus, it's been 20 years. Memories fade. Let's use our reason and common sense here. He faked a kidnapping and then gets a car that's associated with him because Lakeisha lived with him for a period of time, and then goes and dumps a body and then drives the car that they did it in by a payphone that he calls. And again, there's been no evidence that there was any evidence of foul play or anything with Lakeisha's car. Nothing at all. No evidence of concrete found in the car, concrete on him. Nothing. No evidence that when they found him, he was disheveled, dirty. Nothing. It doesn't make sense. Again, this was a parental rights trial. Talked about a lot of other things other than did Dawan cause his death? Because there's no evidence. There's nothing. We're talking about missed doctor's appointments. We're talking about medications. We're talking about all this other stuff. But there's been no talk about any evidence beyond a reasonable doubt that Dawan caused Christian's death. Because it's just not here. We don't have it. Listen, I wouldn't dare stand here and say Dawan was Father of the Year. I would not do that. I'm not going to do that. I know you all heard some things that make you uncomfortable. I'm not going to deny that. I know that. He's made some choices that's uncomfortable. The missed medical appointments, the bed linens. I understand. That's uncomfortable. But that's not evidence that he murdered Christian. You heard evidence that Dawan and Monica had an open relationship. That might make some people uncomfortable. But that doesn't mean they're a murderer. Remember in Vordaer, I asked everyone, and maybe some of you all specifically, that you can set aside any bias or uncomfortableness or whatever and listen to the evidence and make your decision. And now's the time to do that. You need to set a sweet kid, beautiful child. And it's a tragedy for Christian and everyone that loved him, including Dawan and Theta and all of them. But don't twist this and say, well, because Dawan had custody of him, he murdered him. No. That's not what it is. We only convict people of murder in this country if you have actual evidence of murder. You do not have it here. Ignore the drama, ignore the rumors, ignore the innuendos, ignore that. Set it aside. Listen to the evidence. They have not proven beyond a reasonable doubt that Dawan caused Christian's death. They have not done that. The state itself has doubts. You see that where they have alternate counts. They don't know. Dawan's been consistent all these years. The witnesses have not. DeShonda wasn't consistent. She claimed about something, saw Dawan in a threshold when she woke up in the morning. She never told Liza Ludovico that. And Liza said when she talked to her, she was asking about the night or morning hours of Christian's disappearance. She never told her that. It didn't happen. And she talked to her within months of his disappearance. Didn't happen. And she was interviewed at school, away from her parents, no influence. Never said that happened. Didn't happen. Remember when I said when I first started, throw it against the wall, see what sticks? There's nothing sticking. The state has not met its burden. If you still have questions, if you still have doubts, the benefit goes to Dawan, not them. The state has not met its burden beyond a reasonable doubt that Dawan killed Christian Ferguson. Now the state gets another chance to come and talk to you. I don't. So please, with everything that you hear, the question is now, is this evidence that Dawan killed Christian? Not that Dawan's a bad dad, not that Dawan's neglectful, not this. No. Is it evidence of murder? And have they proven that Dawan killed Christian? I ask you when you deliberate that you find Dawan Ferguson not guilty of all charges. Thank you.
All right, thank you. I think we'll take a stretch break at this time, and Ms. Schlesinger, then we'll hear from you, okay? So let's all take a stretch break and give the reporter a break too. If anybody needs to leave, this is a good time. Just 1 minute, Mr. Schlesinger. We'll get started here. Everybody gets settled back in. Okay, great. Thank you. All right, you may proceed.
Thank you. Defense counsel was just up here, and she talked about this case being a parental dispute. And she talked about the state's evidence of it's just medications, just missed appointments. The argument is offensive. This is not a parent that missed a single doctor appointment. This is not a parent that forgot to give a child their morning Tylenol when they have a headache. That's not what this is. Christian's medications, Christian's doctor's appointments were essential to keeping him alive. So to treat it like it's nothing and to talk about this trial as a dispute between parents is offensive and an insult to his memory. This is not a normal situation, and it shouldn't be considered like a normal situation. It's different, and it should be considered differently. Defense counsel talked to you about a lot of things. I'm going to try to address most of them in the time I have left. She used the term rumors, theories, innuendos, but not actual evidence. She said that a few times, which I find slightly ironic, given that that is exactly what she is trying to do with you in regards to Theta. She wants to allude to the fact that Theta person has somehow influenced all of these people to go against Dawan. Yet she doesn't have any actual evidence to support her theory. This trial is not about Theta. Think about the evidence you heard in this case. The only evidence you heard about Theta was a mother trying to figure out what happened to her son. That's it. Nothing more, nothing less. a mother trying to figure out what had happened to her son. She implied that Santana Contreras somehow concocted this whole story after, I believe it was a 2-minute conversation over the phone when they had never met before. And yet somehow in that 2-minute phone conversation, because they have a mutual friend on Facebook, somehow brought this woman to make up this whole story 19 years later. No. Let's talk a little bit about Santana Contreras. You saw her walk into this courtroom. You saw her take the stand. She was trembling. She was afraid. She has every right to be. Miss Steele was making a big deal about how she didn't call 911. She didn't. She talked about it. She talked about her reasons why. She was terrified. 2 people had just made this statement to her. I believe she called it a heinous act. And she didn't know what to do. She panicked. She wrote a letter to her mom saying, if anything happened to me, this is why. She moved out of the state. Within a week after this happening, left her job, left her family, and has never returned since. And she talks about how she continued to be afraid because when Dawan and Monica were pursuing her, these little gift bags were left on her door. She doesn't know for sure it's them, but they were approaching her about this relationship, and the gift bags continued in Wichita. I'm not saying the defendant did it, but it explains why she was afraid, and she thought he did it, and that's what's important. She thought he might have been following her. And she came in here from out of state 19 years later, took the stand, had to have him staring at her, and she told you what happened. Look at her demeanor while testifying. Follow the instructions as it relates to witness credibility. Santana Contreras is a credible witness. And also, if this was some sort of concocted or made up confession, it would have been better. She would have said, I killed him by taking him in the other room and strangling him, and then I put his body in a foundation of a home. All she said was, Dawan Ferguson told me that the boy was dead before he made the call. Ms. Steele tried talking about how it was 2 days earlier, a week earlier, and how she had tried to trip her up on that, but she told you he never said that. That was my impression from it. The only thing she heard was that he was dead before he made that 911 call. He made statements to her, derogatory statements about his ex-wife, about Theda. She told Theda about what Dawan had said, sure, but there was no testimony or evidence that Theda told her to say that, none at all. All Theda did was put her in contact with the person Theda knew to be leading the investigation. Like any mother would. You receive a call about something about your child, you put them in contact with the person that is investigating it. It's normal. And to imply otherwise, there's no evidence to support it. And let's talk a little bit about Santana, because the defense in their case actually put up competing theories. They put up Monica, who said, I have no idea who Cherie Holder is. That conversation never happened. There was never any sexual harassment. She never worked at the Avenue. Don't know who she is.
Objection, that's not a fact and evidence.
That'll be overruled. The jury will remember the evidence as they recall hearing it and seeing it.
Thank you. And then they also called Sonia. And Sonia testified, I do remember Santana. She was referred to as Cherie at the time. I was her manager. I hired her. She reported to me that Dawan Ferguson and Monica Ferguson had been sexually harassing her. Both theories can't be true, and the defense can't have it that way. What Sonia says actually corroborates what Santana said. She worked there. She knew Monica. She knew Sonia. There was some sort of sexual harassment that went on that actually corroborates why Santana was afraid of them. Their own evidence supports the state's theory. Miss Steele got up here and made statements to you about how, if you believe there's a possibility of this, if you believe there's a possibility of that, then it must be not guilty. That's not accurate. The law does not require proof that overcomes all possible doubt. It's in the instructions, and that was discussed in jury selection. So that's not true. Just because there's a possibility does not mean he is not guilty beyond a reasonable doubt. The law does not require proof beyond all possible doubt. It requires proof beyond a reasonable doubt. A reasonable doubt is evidence that leaves you firmly convinced. Ms. Steele also talked about how this case relies heavily on circumstantial evidence. We talked about circumstantial evidence in jury selection. Circumstantial evidence is equally important to any other type of evidence. But we also have direct evidence. We have the statements by Dawan. We have the observations of Lynn Ferguson. We have the observations of DeShonda. We have the medication records that show that he wasn't receiving them. We have the missed appointments. We have the missed visits. We have all of it. Ms. Steele keeps saying that the evidence is theories and innuendos, but that's not true. It is evidence. Let's talk a little bit more about this 911 call. She made statements to you about how it would be reasonable that an individual would leave the car abandoned with things in it because it might have been a cop car. So then you take the child, but you leave the things in there, but you take the child. It's a cop car, so I want to get away from here, and then also take the child? No. Let's talk about what was left in Dawan Ferguson's car. This was admitted into evidence. It is a laptop, cell phone with a charger in his car when it was allegedly carjacked. Think about that. Yet Dawan Ferguson had to stop at a payphone.
What was that exhibit number for the record?
45.
Thank you.
She also talked about how the nurses talked about there always being medication there and there never being any short supply. These photographs were also admitted into evidence, and I want to show them to you, and I want you to draw the reasonable inferences from them. These are photographs of the pill bottles that were seized by Dawan Ferguson's defense lawyer. The date on it is April 18th, 2002, and look how full that one is too. The pill bottles, the medications from almost a year or two ago that are nearly full, were seized by his defense attorney. And she made it seem like they just turned that over to the police when the police asked for it. That's not true. The police had to obtain a grand jury subpoena in order to get those from his lawyer. And the lawyer, nor the Metro One investigators, ever told the police about its existence at all. It's only after they received a tip from neighbors that a team had gone into the house and taken things that the police suspected something might have been missing. Something might have been taken. So don't be fooled by that. But instead, think about what that means. Ms. Steele indicated that we don't have any evidence to show motive. Well, first of all, I don't need to prove motive. Motive is not an element. Not at all. So while I don't even have to, we do have motive. Dawan Ferguson did not care for his child for years, but specifically months leading into June. And then he had to go to court on June 9th of 2003, and he suddenly was told, produce the child or risk being held in contempt. 2 days later is when this happened, when he made the 911 call. His time was up. He couldn't get away with it any longer. That is motive. There are several things on here, several pieces of evidence that the defense cannot explain away.
Objection, burden shifting.
Response?
Your Honor, it's countering her arguments and things that she said.
Yeah, I'll overrule the objection. You may continue.
Thank you. There are several pieces of evidence that the defense cannot explain away. The pharmacy records, the food shortages, the statements by the nurse, other than they try to minimize it or blame the nurses, but they can't dispute what was told. The car being seen on Ron Bar, Lakeisha May's clothes being in the car. There's nobody in the house from March of 2003 until June that can talk about what Christian looked like then, other than Lynn and DeShonda. It's not a single witness that proves the case, but it's a combination and culmination of all of the witnesses. Ms. Steele's right. We put on a ton of witnesses, and a lot of them didn't have a ton to say. Some of them had their small piece to contribute, but everything they said is evidence, and all of it is to be considered by you. Everything about the observations from the nurses, the concerns and observations from the doctors, the disputing of the 911 call, everything. Let's talk about Lynn Ferguson. She got up here and she told you what she saw on June 10th of 2003 leading into June 11th. Lynn Ferguson is a character. You saw her when she was a child in her CAC interview. You saw her here on the stand. Lynn Ferguson is very charismatic and opinionated. But pay attention. She also corrects people a lot. She corrected me. She corrected Ms. Steele. She corrected the interviewer. No one is influencing what Lynn Ferguson has to say. She talks about what she remembers seeing as a child. She talks about how she might not have processed it the same way back then. But you also heard from Martha Finnegan, the trained forensic interviewer. She talked about that process of disclosure, and she talked about memory. She talked about blocks on why a child may or may not say something at the time. She will talk about how a child may say certain things but leave out other details. They talk about how a child's story sometimes develops as they get older and how it's common and expected. It would be more concerning or more unusual if it was the exact same every single time. She explained in her expertise how that is a process and that is common and accepted. But one of the blocks she talks about was parental influences or family influences, environmental influences, things like that. Do you remember on that CAC interview? She asks, who's watching this? Who's this going to? And you know who she was concerned about seeing it? Was her grandparents, the defendant's parents, John Steffen and Dawana Steffen, who she was living with. And after she was assured that John and Dawana Steffen would not see it, she says in that CAC interview that when Christian came back from the other room with his dad, he was asleep and he wasn't moaning. So the defense introduced into evidence and read for you the statement between John Rogers and Lynn after that CAC. And you know who was sitting right next to her? Dawana Steffen, the same person that she was concerned would ever see that CAC interview. Think about that. Ms. Steele said repeatedly that this case had not been proven beyond a reasonable doubt. And that's her job. But she is wrong. It has been. I don't need to prove the actual cause of death. It's not an element.
Misstatement of law.
I'm sorry.
Objection, misstatement of law.
That's overruled. You may continue.
Thank you. I don't actually have to prove the cause of death. I have to prove that the defendant caused it. No one's really disputing that Christian Ferguson is dead. There was doctor testimony that would establish that he would have absolutely died without medical intervention, and that never happened. But Christian Ferguson was dead when he was taken out of that house that day. Dawan Ferguson is the only person that had care, custody, and control of Christian Ferguson for those years. He was responsible for him. He failed to provide him with his medication, nutrition. He brought him to the brink of death, and then when his time ran out, he killed him. He caused his death. He's the one that removed him from the home. He was the last one seen with him. And then he staged a fake cover-up to try and get away with it. And we have the element of deliberation, absolutely. Every act he did over those 2-year periods is a deliberate act. Everything he did that night is a deliberate act. The element of deliberation has been met. And let's talk about what Dawan did, or rather didn't do, after. You heard testimony. There was organized searches. There were prayer vigils. Dawan Ferguson told Ruth Todd, don't go to those. He told Lakeisha Mays, don't talk to the police.
Objection, fact not in evidence.
That was
Approach, please.
That was testified.
All right, ladies and gentlemen, there was an objection, and the court has sustained that objection. I'll ask you to please disregard Mr. Schlesinger's last statement. The record will be stricken, and if you would proceed, maybe restate your point.
Sure. Dawan Ferguson talked to Lakeisha Mays, and I apologize. He said, "You don't have to speak to the police." There were several organized search parties looking for Christian, and Dawan Ferguson never attended them. There were prayer vigils for Christian Ferguson. Dawan Ferguson never attended them. And I want you to ask yourselves, why? At the beginning of this case, you did not know any of the evidence. A week later, you have sat here, you have listened to the evidence, and if you're sitting there thinking, he did it, it's because it's been proven to you. This is an old case, 19 years. That doesn't mean the evidence is gone. You heard it. Doesn't mean the evidence is bad. It's not. When you go back into that jury deliberation room, remember everything you've heard. Remember how Christian and what he was like before 2001. Remember that video of him walking around. Remember that this didn't have to happen. He didn't have to become the disabled boy that he was in 2001, 2002, and 2003. Think about all the actions that the defendant did to neglect and ignore him. Think of all the medications he didn't receive. And think about what Dawan Ferguson did to him when he knew his time was up. Christian Ferguson deserves justice for being murdered by his father. His family deserves justice. He has gotten away with it for too long. Don't be another part of the system that fails him now. Find Dawan Ferguson guilty of murder in the first degree. Thank you.
All right, thank you, Ms. Schlesinger. Would you give those instructions, are those put back in order? Or could you see for me, please? I got it. Okay, thank you. All right, ladies and gentlemen, now becomes your task to retire to the jury deliberation room, select a four-person, deliberate, and arrive at a verdict. Tim will escort you back. I'm going to give to him the instructions and the verdict forms. After you've selected a four-person, you begin your deliberation. Should you have any questions or wants a request or whatever, the four-person, please, will get Tim's attention. He'll be sitting outside the door, and only the four-person, please. Give to Tim. Tim will have some forms for you for the four-person to fill out, and it needs to be signed, and the request or question can be made. Don't ask Tim about it. Just fold it up, give it to him. He'll bring it to me. I'll visit with the attorneys, and we'll get back to you as quickly as we can, okay? If the alternates would stay with me for a second, I'd appreciate that. And Tim, if you take the jurors back, please.
All right.
Oh, and take your notebooks with you. I'm sorry. Thank you.